All right, I'd like to call the Tuesday, October 24th special called meeting to order. Madam Clerk, can you call the roll, please?
Yes, ma'am. Mr. Connolly is absent. Ms. Decatur?
Here.
Ms. Egan?
Here.
Ms. Hazard?
Here.
Ms. Healy?
Here.
Mr. Hirons?
Here.
Mr. McCosker?
Here.
Madam Chair, you have a quorum.
Okay, if we would like to move on to the approval of the agenda for this evening. If I can have a motion to approve.
Motion to approve?
Second.
Okay, it's been moved and seconded. All those, any comments prior to approval of the agenda? Okay. Hearing none, all those in favor, please say aye.
Aye.
Any opposed? Okay, the motion carries unanimously. Next, we will be convening in closed session. Ms. Healy or Ms. Egan, can you read us into closed session if you have it up? Yes.
I move that the Stafford County Board convene a closed meeting to discuss and consider the performance of a specific employee of the school board pursuant to Section 2.2-3711A1 of the Code of Virginia and to consult with its legal counsel regarding a specific matter requiring the provision of legal advice by such counsel pursuant to Section 2.2-3711A8 of the Code of Virginia and to dispense with the attendance of the superintendent at such meeting pursuant to Sections 22.169 and 22.13.313E of the Code of Virginia.
Is there a second?
Second.
Okay, it's been moved and seconded. Any discussion or
Madam
comment?
Chair?
Yes.
I have a comment and I guess a point of personal privilege. I just want to make this statement. We as school board members are elected officials, and all elected officials take an oath of office upon stepping into this job. With the case before us, I began at believing I could hear the evidence and the arguments and make an objective decision based on the facts. However, after testimony and as we began deliberations, I quickly realized I could not. As we listened to witnesses speak about the talents and dedication of Rebecca Whitford, I could not remove myself from their position. Not one of them spoke with exaggeration or hyperbole of Rebecca's ability and value to Stafford County Public Schools. Having been a parent in her classroom and having developed a friendship with her, I would have rather been able to speak using many of the same words as the witnesses did on her behalf. As we began deliberation, I, like many of those who sat before us, could see no reason and no way I could support any action against her. With that, I knew I was not listening with an objective ear to the arguments of the administration. Unfortunately, that is not in line with the oath of office I swore to uphold before my friends, family, fellow Stafford County citizens, and God. Not upholding the oath would not be fair to the people I represent in Stafford County Public Schools or the rules, laws of Stafford County and the Commonwealth of Virginia. That is why I've recused myself from further action in this case, and in a few minutes will excuse myself from the dais. However, I do want to make it clear I give my full trust to my fellow board members who have to make this difficult decision, and they will take everything into consideration. The worst part here is the state code that brings us here. The state code, in my opinion, is unforgiving and incredibly overburdening in this case. The action of the school board has to take, the potential action the school board has to take on this is not dictated by the will of Stafford County or Stafford County Public Schools. It is the dictation by the state government and standards of the SOLs. Now, I don't envy my fellow board members, but as I state, I do trust their hearts are heavy with this case and will ultimately make a decision that is objective with the full consideration of all the facts and concerns. With that, I restate that I have and will continue to recuse myself from any further action in this case, and I'll now step down from the dais for the remainder of this meeting.
Okay, thank you, Mr. Hirons. Any other comments or Mr. McCosker?
Thank you, Madam Chair. I too will abstain from and not join the special called meeting, and that's based on the absence of, I was absent during the initial full day's legal proceedings, and I just don't have all the facts. I just would like to pass on to the board those things that I did hear, let's remember, intent versus impact, the intent and the impact of what happened, and just make the right call.
Okay, thank you. All right, well, all those in favor, please say aye. Aye. Any opposed? All right, we are in closed session. Yes, go ahead.
Whereas Section 2.2-3712 of the Code of Virginia, 1950 as amended, requires certification by this school board that such closed meeting was conducted in conformity with Virginia law. Now, therefore, be it resolved that the Stafford County School Board hereby certifies that, to the best of each member's knowledge, only public business matters lawfully exempted from open meeting requirements by Virginia law were discussed in the closed meeting to which the certification applies, and only such public matters, business matters, as were identified in the motion convening the closed meeting were heard, discussed, or considered.
Is there a second?
Second.
Madam Clerk, can you poll the board, please?
Ms. Decatur?
Agreed.
Ms. Egan?
Agreed.
Ms. Hazard?
Agree.
Ms. Healy?
Agree.
Madam Chair, motion passes unanimously.
Thank you. Is there any action coming out of closed session? At this time, I will read a proposed decision on behalf of the board, and then I will entertain motions. On September 27th, 2017, a hearing was held before the Stafford County School Board on two matters concerning Rebecca Whitford, a third-grade teacher at Conway Elementary School. One, the superintendent's recommendation to dismiss Ms. Whitford from employment, and two, the superintendent's petition for revocation of Ms. Whitford's teaching license. On September 21st, 2017, Ms. Whitford, through counsel, requested that the hearing be open to the public. At the start of the September 27 hearing, the school board granted the request and proceeded to conduct the hearing in open session. Ms. Whitford was represented at the hearing by her counsel, Michelle Chioka, and the school division was represented by Stacy Haney. The hearing was conducted before the following school board members: Holly Hazard, Scott Hirons, Jamie Decatur, Irene Egan, and Patricia Healy. At the start of the hearing, Mr. Hirons disclosed that he and his wife have a personal relationship or friendship with Ms. Whitford and her husband. Neither counsel for Ms. Whitford nor the division's counsel objected to Mr. Hirons' participation in the hearing. During the day-long hearing, the school board heard the testimony of numerous witnesses and received into evidence exhibits from the division and exhibits from Ms. Whitford. After closing statements of counsel, the school board met in closed session to deliberate. At that time, Mr. Hirons recused himself from further participation in these matters due to his family's relationship with Ms. Whitford. The school board thereafter continued its deliberations without Mr. Hirons' participation. By letter from Ms. Hazard dated October 13th, 2017, copies of which were sent to counsel for Ms. Whitford and the division, the school board requested certain data from Dr. Elena Parrish regarding the numbers of SOL testing irregularities in Stafford County Public Schools over the past 5 years that were reported to Stafford County Public Schools, subsequently reported to the Virginia Department of Education, and any actions directed by VDOE. Dr. Parrish sent a written response on October 23rd, which was also sent to Ms. Whitford and the division's counsel the same day. Ms. Whitford, through her counsel, transmitted a letter to the school board dated October 24th, 2017. Actually, it was dated October 23rd, received on October 24th, responding to Dr. Parrish's data and providing additional information and arguments for the board's consideration. Later that same day, this matter was continued into the closed session just before this time. The school board's factual findings based on the evidence. The evidence and testimony presented to the school board established that on Saturday, May 27th, 2017, 5 days before the third graders at Conway Elementary were scheduled to take their math SOL test, Ms. Whitford sent a group text to the other 5 members of the Conway Elementary third grade teaching team in which she stated, comparing, adding, and subtracting fractions using fraction models, money word problems, count the money, subtract the price, how much change, elapsed time, probability word problems, lots of graphs. The second bullet was, this is from a little birdie about the math SOL. One of the 5 recipients, a first-year teacher and member of the 3rd grade team, responded, "Thank you." None of the other members responded to the text. At the time Ms. Whitford sent this text to her colleagues, she had been a teacher for more than 25 years. She'd administered and proctored SOL tests. She also received training on SOL test administration. In that training, SOL test examiners and proctors are instructed not to talk about the content of the SOL test before, during, or after the test, unless that test had been publicly released by the Department of Education. They are provided an examiner's manual, which reminds examiners and proctors in Section 5.3.1 that examiners and proctors are prohibited from discussing test items with anyone. They are also required to sign the school division personnel test security agreement, which Ms. Whitford did for the spring 2017 SOL tests on May 1st, 2017. In that agreement, she confirmed that she had read, understood, and agreed, among other things, that reading or reviewing any part of a secure test, test items, answer options, passages, pictures, diagrams, charts, maps, before, during, or after the test administration is a violation of test security, except when it is done as part of or in preparation for providing an accommodation, and capturing all or any part of a secure test is a violation of test security. Prohibited actions include copying, photographing, recording, outlining, or summarizing the test content or details regarding the secure test content. Ms. Whitford also there agreed that she had read the legislation passed by the Virginia General Assembly regarding mandatory tests and violations related to secure mandatory tests. 2, that she understood that if test security procedures are not followed, my license may be suspended or revoked and/or may be assessed a civil penalty for each violation. And 3, agreed that all known or suspected violations of SOL test security will be reported to the appropriate school division personnel or to the Virginia Department of Education. On Tuesday, May 30th, 2017, the next business day after Ms. Whitford sent her group text to her fellow 3rd grade teaching team members, one of the recipients reported the text to the administration at Conway Elementary School. After reviewing the text, the principal spoke to the division director of testing, Dr. Elena Parrish. Dr. Parrish reviewed the text. She then contacted the VDOE and reported a potential testing irregularity. She was advised by Jason Ellis, a staff member in that VDOE office, to conduct an investigation. Mr. Ellis also advised that it was important that Dr. Parrish ascertain the identity of Ms. Whitford's source. Dr. Parrish interviewed all the recipients of Ms. Whitford's text message and Ms. Whitford herself. Each of them provided written signed statements to Dr. Parrish. All of the text recipients indicated that they all understood the text as relaying content that was going to be on the upcoming math SOLs. Ms. Perry stated that when she received the text, she knew immediately it was wrong and that she needed to report it, which she did on the first day she returned to school. Another teacher, April Massini, also understood the text as relaying content that was going to be on the math SOL, so she closed it out immediately and did not respond. A third teacher, Carrie Frank, stated that she also understood the text as stating a few math concepts that would be covered on the 2017 math SOL. She discussed the text with her husband, and they talked about not responding. Melanie Newton, a 4th grade teacher, said that she received the text while driving, that her husband read her the text, that she directed him to delete it, and that he did so. Ms. Newton also advised Ms. Puckett, who was her mentee on the next working day, that she should not have responded to the text. Ms. Puckett explained to Dr. Parrish that her thank you text had been a reflexive response. The teachers all confirmed that they did not otherwise discuss the text message among themselves. In her interview, Ms. Whitford confirmed that she had sent the text. She told Dr. Parrish she had sent the text after speaking to a teacher from another school who had been visiting her home that Saturday. The teacher had told her to make sure you cover these areas when practicing the SOL, and Ms. Whitford sent the text to her fellow 3rd grade teachers because I wanted to make sure my colleagues were covering the right material. Her written statement similarly stated, I received information about what to make sure I reviewed with my kids. The original information was done orally. No questions were addressed. Dr. Parrish asked Ms. Whitford to identify the little birdie from whom she obtained this information, but Ms. Whitford refused. Dr. Parrish explained that this information was necessary to assess the scope of the problem and the extent of corrective measures that needed to be taken. Ms. Whitford then revealed only that this little birdie was not a teacher at Conway Elementary. At VDOE's direction, Dr. Parrish removed Ms. Whitford and from all SOL testing responsibilities. As an additional precaution to protect the integrity of the testing process, the remaining Conway third grade team members were also not used as examiners or proctors for the third grade math SOL. Instead, the Conway fourth grade team administered and proctored the third grade math SOL on Thursday, June 1st, while the third grade team members, other than Ms. Whitford, served as proctors and examiners for the fourth grade SOL test that day. The administration at Conway Elementary had previously indicated that the SOL test would be administered to students in their regular classroom setting with their regular teachers because it is believed that students perform best when the testing environment closely approximates the environment in which they learned and practiced the material. Administration had to grapple with how to explain these last-minute staffing changes to students and parents and to worry about the potential impact on students' performance. As she was required to do, Dr. Parrish provided her investigative notes, written statements, and copies of the text message to Mr. Ellis with VDOE. VDOE issued a determination on June 7, 2017, finding that Ms. Whitford's actions had violated multiple items on the 2016-17 School Division Personnel Test Security Agreement. Stafford County Public Schools Regulation 4902-R provides that teachers may be dismissed for incompetency, immorality, noncompliance with school laws and regulations, disability in accordance with state and federal law, conviction of a felony, or a crime of moral turpitude or other good or just cause. Section 22.1-292-1 of the Code of Virginia lists 10 acts relating to secure mandatory tests administered to students, which tests include SOL tests, and provides that the Board of Education may suspend or revoke the administrative or teaching license it is issued to any person who knowingly and willfully commits any of these acts. Those acts include divulging the contents of any portion of a secure test, failing to follow test security procedures established by the Department of Education, and participating in, directing, aiding, assisting in, or encouraging any of the acts prohibited by this section. Having reviewed all the evidence and exhibits and listening to the testimony provided at the hearing and the arguments of counsel, the school board finds just cause to dismiss Ms. Whitford. Her conduct violated Virginia Code 22.1-292-1A, the School Division Personnel Test Security Agreement, and the school board's expectations as set forth in our adopted strategic plan. Stafford County Public Schools identifies 5 district values of the school division: learners, community, excellence, respect, and integrity. Ms. Whitford's actions regarding the sharing of testing information did not comport with the division's expectations and values for its staff and students. Her actions jeopardized the integrity of the 2017 third grade math SOL testing at Conway Elementary, caused significant disruption to her school, and imposed additional burdens on staff, students, and parents during the SOL testing process. The school board further finds that Ms. Whitford's actions in violation of Virginia Code 22.1-291-1A were knowing and willful. It recommends to the the Virginia Board of Education that Ms. Whitford's teaching license be suspended for a period of 1 year. In reaching these decisions, the school board rejects Ms. Whitford's argument that her group text was acceptable because it did not disclose any specific questions from the SOL test. Both 22.1-292-1A and the School Division Personnel Test Security Agreement clearly prohibit summarizing the content of a secure mandatory test, such as the SOL test. The school board also rejects Ms. Whitford's arguments that her actions were lawful because the math concepts in her text can also be found in the curriculum framework and other publicly available information about the standards of learning for third grade math. The third grade math SOL questions are based on the third grade curriculum. Of course, any summary or description of the third grade math SOL test would necessarily include contents that are included in the third grade curriculum framework. But the curriculum framework and the other published documents in Ms. Whitford's exhibits identify dozens of math concepts, while Ms. Whitford's text mentioned only 6. Furthermore, according to Ms. Whitford's written and oral statements to Dr. Parrish and her own testimony, she did not send the text to her colleagues because she had been reviewing the curriculum framework that Saturday. Instead, Ms. Whitford sent the text because she had been speaking to a friend who was a third grade teacher from outside Conway Elementary about the third grade math SOL test. According to Ms. Whitford, she wanted to make sure that they were reviewing the right material with their students. the 6 concepts listed in her text. Her text also made clear that the source of her information was not from a publication of the Department of Education. This is from a little birdie about the math SOL. Furthermore, if these concepts are on every 3rd grade math SOL test, then Ms. Whitford would not have felt compelled to share this information in a group text to all of her colleagues in the middle of a holiday weekend. The school board does not find credible Ms. Whitford's testimony that she did not know whether or not her little birdie had already administered the 2017 3rd grade math SOL. Had Ms. Whitford not believed that her source had inside information about the test, she would not have said this is from a little birdie about the math SOL. It is telling that Ms. Whitford's colleagues on the 3rd grade team inferred that from this statement that the little birdie knew what was on the 3rd grade math SOL test. So did Dr. Parrish, so did VDOE. That is the only logical inference to be drawn from Ms. Whitford's little birdie statement. The school board finds very troubling that Ms. Whitford withheld and continues to withhold the name of the teacher who provided this information to her. It is also troubled by the shifting answers that Ms. Whitford gave to the school board members' questions during the hearing about her unwillingness to reveal her source's place of employment to anyone in administration. Ms. Whitford initially testified that she had identified her source's place of employment to Mr. Raybould when Dr. Parrish's investigation began. She later contradicted that testimony, now claiming that what she had told him was that her source did not work for Stafford County Public Schools. But even that testimony was not credible. Mr. Raybould testified that Ms. Whitford did not tell him that her source was not a Stafford County employee. Moreover, to the day of September 27th, 2017 hearing date, he still did not know in which school division Ms. Whitford's source was employed. Mr. Raybould's testimony was also consistent with Dr. Parrish's testimony, who said Ms. Whitford would only say on that first day that her source was not someone at Conway Elementary, and that Dr. Parrish did not learn until sometime later that Ms. Whitford's source does not work for Stafford County Public Schools. The most that Ms. Whitford has ever said to administration is that her source does not work for Stafford County Public Schools, but that does not foreclose the possibility and the administration's legitimate concern that her source shared or is continuing to share the same or similar information with other Stafford County Public School teachers as she did with Ms. Whitford. Ms. Whitford's refusal to identify her source not only aids the teacher's violations of 22.1292(1A), but also frustrates and impedes the administration's ability to determine the scope and extent of the problem and to implement corrective measures. The school board recognizes that Ms. Whitford has had a long career as a teacher and has received strong performance evaluations. These do not, however, excuse Ms. Whitford's violation of Virginia law and SOL test security procedures or mitigate the significant impact that her actions had on her school, colleagues, students, and administrators. Nonetheless, it is in the view of Ms. Whitford's prior performance record, the school board finds that the appropriate recommendation to the Board of Education should be for a 1-year period of suspension rather than revocation of her teaching license. Is there a motion or?
Madam Chairman, I move to accept the superintendent's recommendation to dismiss Ms. Rebecca Whitford from employment as a teacher, to grant in part the superintendent's petition for licensure revocation by recommending to the Virginia Board of Education that Ms. Whitford's teaching license be suspended for a period of 1 year, to adopt a proposed decision setting forth the school board's findings and rationale based on its hearing on these matters, and provide the parties a written copy of the decision.
Second.
Is there a second? Is there any further discussion or comment? All those in favor, please say aye. Aye. Any opposed? Motion carries unanimously, I believe.
It passes by a vote of 4-0 with 3 abstentions.
Okay. That's what I wanted to make sure was reflected in the record. Thank you. All right, at this time, we will adjourn the special called meeting and take a 5-minute break, and we will resume at 7:20. Thank you to those in the JROTC. We really will be back in 5 minutes. Thank you.